Okay, well, thank you everybody for coming to today's World Court of Human Rights Coalition meeting. Pleased to welcome Professor Jocelyn Getgen Kestenbaum, who I will introduce momentarily after just a few comments about the World Court of Human Rights Coalition. Back in May of 2023, we did submit to the NGO branch of the United Nations, ECOSOC, a petition to have an application approved for consultative status. We found out later that they've been overwhelmed with requests for consultative status. We were expecting by this last June of 2024 to have an answer. We did actually over the summer get what I would call, it says it on their website, an initial clearance, but a final clearance by one of their officers is still required. And I don't know how long that will take, but hopefully by maybe this coming June of 2025, we'll finally have the capability to attend UN meetings, and we hope to meet with the third and sixth committees of the UN to discuss a future World Court of Human Rights. We are still seeking government outreach coordinators for various parts of the world. So if you know of anybody who might want to volunteer for the World Court of Human Rights Coalition, please email to info@worldcourtofhumanrights.net, or I put in my email previously in the chat, david@worldcitizengov.org. Okay, well, so with that brief introduction, now I'd like to introduce our speaker today, our expert speaker, Professor Jocelyn Getgen Kestenbaum. She is professor of law at Cardozo School of Law, where she directs the Benjamin B. Ferencz Human Rights and Atrocity Prevention Clinic and the Cardozo Law Institute in Holocaust and Human Rights. Her scholarship focuses on human rights, public health, and atrocity prevention, especially related to preventing and responding to sexual and gender-based crimes, slavery in the slave trade, indigenous rights, and human rights violence against minority groups. She's created law teaching guides on confronting structural violence to include atrocity prevention in law school curricula, and help law faculty bring into their lectures discussions about the role that law and lawyers can play to prevent and address systematic discrimination and violence. And I sincerely appreciate Jocelyn for speaking with us today. Thank you so much. So the floor is yours. This is, as I mentioned, a relaxed conversation. So I would like you to talk about what you would like to talk about, and then we'll maybe bring it back to the court by the end of the conversation today.
Okay, well, thank you so much for the invitation and thank you for exposing me actually to the project or the coalition for this World Court on Human Rights. It's an exciting type of project, and I say this with the utmost sincerity because I had been working up until his death, not untimely, with Benjamin B. Ferencz, who made it to 103. And one of his, life's works, projects was to create the International Criminal Court. And even he, it took decades and, lots of advocacy and lots of coalition building and coordination and sponsorship with states and thinking through, lots of hurdles, lots of challenges, but ultimately received, in the end, or I guess it was established, the International Criminal Court. And now you see it's, you know, challenges continuing, but at least the first iteration of this court working and doing potentially, positive work on the international stage. And even I have my trepidations about international criminal law as where we put all the eggs in our basket, in terms of the work that we do, especially in, human rights defense, and thinking about atrocity prevention. Because really, to me, when your focus is on international criminal accountability or individual liability for atrocity, you are plucking out the maybe worst bad actors, not even all bad actors, but the worst bad actors, and allowing for a structure to continue that is perpetuating in many ways the very atrocities that we're trying to address or trying to prevent, trying to redress. And so I love the idea that there is still a need or a momentum for building an international world court on human rights, because what that does is it focuses not only away from individual criminal accountability, which, I guess at the domestic level, you would still be thinking about individual criminal liability for a lot of human rights violations, but you are thinking about state responsibility for these particular harms much more squarely. And you are thinking about the structures um, that largely, if we're talking about redress, then you're focusing on the individuals or the collectives sometimes that are most affected by atrocity crimes. And so it's a way to, I think, focus more on the subjects of human rights, which are individuals and groups. And those are the folks who we should be centering and elevating in our work. And so the idea of the World Court to me is exciting in that regard because it really is putting an emphasis on the states being responsible for anything and everything that happens human rights wise within their borders and to every individual within their borders. And that responsibility allows us to move up in the continuum, what I would say is the continuum of violence. I think with my public health head when I'm thinking about violence prevention. And if we can move further upstream, so not when we're seeing mass atrocity outbreak, and at that point we have very few legal tools. A lot of the tools are political and even military at that stage, and whether or not that is in any way preventative of mass violence is questionable. But it certainly can even accelerate or not mitigate atrocity crimes. So the more we can focus on human rights violations, where we have the beginnings of what may escalate to mass atrocity, then we're thinking more with a lens of prevention. And the law, the way we learn and the way we teach law is mostly terrible at prevention. We're often thinking about harms that have occurred and how do we account for those harms, rather than thinking about how do we use the law as a tool to intervene at a point that is upstream from where we want to be ensuring that these crimes and these atrocities are not occurring. So that's just my way of saying I'm very happy that this project is happening. And I'd really love to hear from everyone on this call the ways in which they're engaging, and the ways in which others like me can engage in a project to secure a world court like this. So I was asked a couple of general questions. So I'll just go through some of the thoughts and the sort of answers that I had to the questions that were posed to me. One was about how I became interested in teaching in law clinics and as a pracademic, which I do call myself a pracademic because I really do enjoy practicing human rights law. I don't think it's an academic exercise. I think it matters on the ground that there are individuals who are harmed every day by their states or non-state actors and need redress. And so I feel that, the work that we do as human rights practitioners is vital and important. And I would not want to just sit in an ivory tower. That's just me. And think about these issues when I know so much needs to happen on the ground to advocate for the redress and reparations for human rights violations. But that wasn't enough for me because I did practice international human rights law. I really also enjoy the academic setting where we have the ability to choose cases and think very strategically and forward thinking about the cases we take on and try to further the law itself. And knowing that human rights law and international law more generally is very, new as law goes. And there is so much still that we should be thinking about and allowing to evolve and change and rethink, right? The way that law serves or doesn't serve humanity. I think that's really at least the way I'm approaching it. And students breathe life into that work and bring new ideas. And so it keeps you, I think, on your toes about the field and how to be cutting edge and innovative and stay ahead, or at least try to stay on top of where the law is going, not just, implementing, but also trying to shape the law in a positive way for improving, right, the way that the law adapts or doesn't to these harms that we see every day on the ground. I started out as a Peace Corps volunteer, which to me now feels so colonial. But but I really was running away from law school. I thought, "Oh, I'm not like all these other people going to law school. I didn't see how I didn't know any lawyers. I'm the first person in my family to go to college, and so definitely to go to law school. And so I took some time to really think about whether or not that investment was worth the price tag. And in Ecuador, I was living and working in a small indigenous community in rural Ecuador in the Andes. And that really opened my eyes to the way, and I had always thought about public health, right? I always felt really connected to health, issues of health, especially reproductive health and women and gender-based violence issues. And that's what I did when I was a Peace Corps volunteer. I was a health volunteer, and what I guess I saw was the way it was just very stark to me to, I guess, when you're out of your own context and culture, and you are able to sort of view from an outsider insider perspective, culture and just relationships and the way in which structures and systems and laws are um, affecting people in their daily lives. It just became really salient to me the way in which the law played a role at um, reinforcing oppressive structures that um, were intersecting and interdependent and reinforcing in situations in everyday lives of especially, women, children, minority groups, indigenous groups. I, saw that firsthand when I was a volunteer. And that just gave me time to really think about, I guess law really is powerful. It's a powerful tool. So I kind of think of myself as a public health professional, and I use the law as a way in which, as a tool to improve health and health outcomes for folks. And then I came back to law school. Really, then I really was different from the other people who I attended law school with. But I found my niche, and I was in the first cohort at Cornell Law, where of the International Human Rights Clinic there. And Professor Sheetal Kalantri was my professor, and she encouraged me at the end of the year-long clinic project work to consider clinical education, that it was something that she thought I would be good at. And so that was the first time someone ever had encouraged me to pursue a particular, um, field, or I guess, area within the field. And so um, then she hired me as her first ever teaching fellow. And I guess the rest is history, because then I really understood and was able to engage in the academic setting, but with a practitioner's ability to work on cases and projects and further human rights work on the ground. So I guess that's where I became interested in it. And after my fellowship, I did go back and work in practice for a little while. I really missed the interactions with students. I missed reflecting also on the work. And so a lot of my writing is really a reflection on the practice work. And I think that really works well with academia. Don't tell any of the podium professors who don't practice, but I do think practice work helps to really inform your scholarship. It makes your scholarship at least tangible or a little bit more accessible to people who then would turn around and want to use it in their practice work. And so I think it's a reinforcing kind of cycle that I enjoy. And a lot of my scholarship, if you care to know about it, and we can talk about it if that's interesting to you, but that is a reflection of the learnings that I have through the practice work in the human rights space. And why did I decide to focus on mass atrocities and the protection of vulnerable populations and accountability for those responsible for crimes against humanity and gross violations of human rights? Again, it is connected to living and working in Indigenous communities. And that in law school led me to work. I received a Tinker grant, and I was able to go to work in the post-conflict Peruvian context. And I did work with Lisa LaPlante, who's at New England Law School. At the time, though, she was with NYU and running a small NGO, and we were working together in the reparations plan for the post-conflict situation in Peru. And when I was working on that reparations plan, it really struck me the ways in which reparations were thought about from a theoretical perspective, and then how it really worked in the practical perspective in people's lives who were recovering and healing in a post-atrocity situation. And it also helped me to see the cracks in the transitional justice response to atrocity. And it made me think about all the ways in which we as practitioners would have to change and be responsible at, thinking really critically about how reparations are developed and implemented in a post-atrocity context. When I worked in Peru, it became really clear as someone who spent a lot of time in Indigenous communities that there was no Indigenous representation, really. Like it was very, I think there was one representative that was Indigenous, but the harms against Indigenous people in that conflict was overwhelming. I mean, it was a majority of the folks who suffered atrocity crimes were Indigenous. And so it just felt wrong to have no or very little representation. And there was one woman on the commission. And the outcome of that commission, while it was, for its time, very innovative and new, I saw the shortcomings of it, and it made me do research into the reproductive violence that had occurred against Quechua-speaking women in, well, and others, but a large number of Quechua-speaking women in Peru were forcibly sterilized during the conflict. And that research and that work really helped me to understand genocide, understand crimes against humanity, war crimes, and understand how particular groups are targeted and the perpetration of that violence and how it can be missed when folks are already facing intersecting and multiple forms of discrimination and marginalization in particular societies, which Indigenous women and girls certainly in Peru were. So that's, I think, the maybe a formative time where I thought I have all of these skills and experience and knowledge, and I also speak languages that can help with the work, that I would focus on, reproductive and gender-based harms, thinking intersectionally with various forms of identity, marginalization, and violence, and in the context of genocide and mass atrocity crimes at the time. But now I work much more on prevention because of the public health focus. And let me think more about, tell us about your work as director of the Human Rights and Atrocity Prevention Clinic and the Institute in Holocaust and Human Rights.
Yeah,
And what roles?
yeah. What's the difference between those two? Yeah,
Okay.
the roles. Yeah, sorry. Go ahead. The roles.
Yeah, sure.
Yeah.
Yeah, so I think of the Institute. So the way in which the Institute received funding was from an unclaimed Holocaust restitution case. So there were unclaimed funds, and those funds started an endowment. And so the Institute, at the time it was a program, was formed in Holocaust and human rights with the idea of never again and to work on and to raise awareness about current atrocities happening. With the lessons of the Holocaust, how do we move forward and prevent other, mass atrocity events from happening? And so that is where the money comes from and the initial funding. And I am the director of that institute. And I think of it as the think tank. It's like where we can think about innovative discussions, strategy sessions. We can do public events. We can raise awareness about certain issues that are, of interest to the fields of human rights and atrocity prevention, and thinking about how do we move forward our thinking and the tools and the ways in which we our understanding of prevention. How do we evolve that and get better, right? Because we're certainly not preventing genocide and mass atrocity harms. Anyone on this call knows if we just open a newspaper, I guess we don't open newspapers anymore, but if we turn on our computers and our devices and we look at what's going on in the world, and many of us, I'm sure, are working on these issues, it's not that we're preventing. It's probably the world is getting escalating, and atrocities are everywhere. Well, I always think of atrocities as everywhere, but maybe it's because of my specific focus. But so the institute is the think tank, and then the action arm is the clinic. And so when we have these ideas and strategies that we're thinking about, then how do we actually implement them and think about them and tweak them and understand how they work in practice? That's when we bring that work into the clinic. And obviously it's not a perfect match because it's not that we're like experimenting on communities or anything like that. We have long-standing relationships and partnerships with communities. And often too, the action arm of the clinic is where we get the ideas for innovation and thinking about how we do this work better. And then you kind of bring that to awareness raising through the Institute. So it's not even that it's one unidirectional. It kind of works both ways. But that's the way I think about it. I think about it as, sort of the theory and the thinking and the innovation and the tools that we were developing to do this work better as the Institute, and then and also the Holocaust history being what grounds us in the work. And so having that connection to history and the historical past and memory, because it's so important as especially as I get into more of the research and the practice in slavery crimes, what I recognize is that there is legal narratives that go forward. There are legal narratives that go forward, and some of those narratives get erased over time. And once they do, then we start to think differently in the present about atrocity harms. The one very concrete example is the crime of the slave trade that Rebecca knows very well because she hears me talk about it a lot. But that crime we don't find in some of our treaties in quote unquote modern international legal instruments. And that is to the detriment of us then not seeing the present day slave trade occurring. And then we don't investigate, prosecute, punish, and don't redress those harms today. And that is a problem. And we need to think about how structurally the architecture, right? Like how and history helps us to understand why do we have slave trade as a prohibition, as a crime, and how it was it seen then and how has it evolved, but how is it still constituted and perpetrated today? for present day redress.
Um,
Okay.
I've got a
Yeah.
question to sort of follow
Sure.
up to that, maybe before we move
Yeah,
on.
of
Some
course.
of those other list of 20 or so questions that I had originally emailed you. Um, can you give us like a current example, whether it's with Gaza or whatever? What are you doing as a practitioner with your students now to try to make change or to understand what's going on and either build coalitions or uh, actually try to reach out to the whether it's the ICC or the ICJ or other venues where you are having the students actually take the action, and then
Yeah.
maybe what you learn from that you take to the institute somehow and then get that out to the public. I don't know. That's what I'm imagining. So if you could explain that process
Yeah.
with a
Okay.
real
So
real current example, maybe if that's possible.
which one to use? Okay, so I guess one concrete example of a justice and accountability project that we're working on that's been a longstanding clinic project from about 2015, 2016 has been justice and accountability for the Yazidi genocide and slavery crimes. And so the Yazidis are a religious, ethno-religious minority um, that ISIS perpetrated uh, crimes on Sinjar. It was an event, right? Like there was an attack on Sinjar, but then throughout that, after that attack and throughout the, following years, ISIS perpetrated a system of slavery and slave trade and multiple atrocity crimes, within those structural systems of criminality and including genocide. And the ICC, as probably many of you know, is not a venue for accountability and justice for the Yazidis, given that the context occur, the territories are not party to the ICC. So it's Iraq and Syria generally. So what have we done? We've been working very, very hard to ensure accountability and justice wherever we can. And that includes a focus on universal jurisdiction. And so we've been working very closely with the various NGOs and representatives of Yazidi victims and their families to ensure that, we're doing what's best for the communities themselves and seeking venues for various cases when perpetrators are found in other countries with universal jurisdiction laws. Then there is advocacy around bringing those particular cases. And once those cases are being brought in a particular country, Germany is one country that has taken on several cases of ISIS perpetration of slavery crimes against and genocide against the Yazidi population. Then we work very closely with the prosecutors and experts to ensure that those cases go forward and that the law is developed in a positive way, that precedent can then be used in other jurisdictions, or we have then, positive case law and the ability for other states to think, oh, we can take on cases like this, or oh, we have ISIS perpetrators in our jurisdiction, so let's go forward with the case. And other cases have occurred in Sweden, the Netherlands. There's several cases. We were involved in a case that was going to go forward in even the U.S. context, but that it ended up that the victims didn't want to move forward with the case, and so we respected their wishes and dropped that particular case. And we also have worked with lawyers on corporate accountability for those particular crimes. So not just individual perpetration, but thinking about the ways in which corporate actors facilitated and basically paid to continue working, paid ISIS, which allowed ISIS to operate and perpetrate all of the crimes that it did, that the perpetrators did in that particular scenario. So we have a case that we're working closely with lawyers in France uh, against Lafarge, which is a French cement company that was operating at that time, and evidence of extortion, payments, bribes to stay open is pretty open and notorious in that case. So trying to get material, you know, reward or like some kind of reparation for the harms as well, because as you might imagine, 10 years out, there's still so much need for the basic necessities for Yazidis in moving on in their lives, but also job training and education and healthcare and other things. So we're working hard to try to make sure that, all these avenues are pursued so that individuals and the Yazidi people can continue. Um, and I guess another example that might not be so evident to folks is well, one, we're thinking about the missing and murdered Indigenous persons crisis in the United States. So Native American women, girls, and Two-Spirit folks go missing at about 5 times and are murdered at about the 5 times the rate of others in the United States. And that is part of a long continuum of genocidal and other violence against Indigenous populations in the Americas and specifically in the US context. And so we are working on preventative efforts in this scenario to think about when folks are at a heightened risk of going missing or murdered, and that is when they have precarious housing situations and when they're aging out of foster care or other institutional care systems. And so in thinking of that like preventative lens, we're trying to work with tribes and the government itself to raise awareness that this is an issue and that this is a continuum of violence and that it stems from conquest and genocidal violence and slavery and slave trading against indigenous populations in the United States. And then to think about how these particular issues, the right to housing, and issues about the foster care system and discrimination and the needs of Indigenous survivors of violence, and that's intimate partners of violence, and that's surviving the foster care system itself. The needs are different, and how to adequately respond to that to stop and prevent these cases of missing and murdered. At the same time, also thinking about how do we raise awareness of that connection or that continuity of genocide and atrocity harms and how that manifests in the afterlives, right? Like thinking about how that manifests today for Indigenous populations. And so there's a lot of work on even just connecting the dots for people. A white paper, for example, that is connecting conquest and genocide against Native peoples to the boarding schools, to the various eras of violence against Native people, and to today's missing and murdered Indigenous persons crisis. So those are just two examples. I do a lot of land claims work too with Indigenous groups, given that, generally speaking, uh, the intent is to destroy a group, but the motive is often different, right? And with Indigenous populations, it's often a economic motive that has to do with resources and land grabbing. And so a lot of the work that we're doing in preventing dispossession and genocidal violence against Indigenous groups in Brazil mostly, but also in Argentina, focuses on land and how do we protect the relationship that Indigenous populations have with land? How do we use the Indigenous rights framework in the human rights system to protect the land rights and collective rights of Indigenous groups? And I often think about Indigenous groups as have a right to exist, right? Like they have a right to be. That's how they have articulated it in the context of Argentina, the el derecho de ser, and that right is, I think, sort of a corollary or the the opposing sort of the right that it goes along with the prohibition of genocide. And so for me, allowing for indigenous populations to exist and to be as such, right? Like as the collective that they are, and to continue and to develop in a like, I guess the right to self-determination is really like buttressing all of that. It is to me a prevention of what would be the corollary, which is the genocide that is ongoing in many of these contexts, in settler, especially settler colonial contexts. I don't know if I even answered your question,
Yeah,
but
no, thank you for all those explanations of current actions. What I really appreciate from what you said is that not only it feels like your clinic is and the institute are providing legal justice, but also social justice and economic justice. That there are other tools of redress that you're implementing. Is that an accurate thought?
yeah, yeah. And so one thing I think that our clinic does as well in training future human rights lawyers, I mean, I hope we're doing it well. We're certainly doing it better than we ever have because we're constantly learning and improving, I think. And that is really taking a critical look at the human rights framework and ensuring that we are teaching human rights law through a more of a third world approach to international law, through a critical approach, anti-racist approach, and decolonial approach to international law. And so what that actually means is that we approach the work, the actual practice of human rights differently. And really, Indigenous partners have taught us a lot of these ways of practicing that are, I think, different than at least how I was taught to practice law. And really, it's about shifting worldview. And I think, what we're trying to bring to the table is that the dominant worldview, the Western gaze, the Eurocentric, way in which international law is made and replicated and even taught is one way of thinking about international law, and that we have to think about other ways of being and knowing as valid, and maybe even elevate those other ways of being and knowing as equally valid. And the cosmovisions of Indigenous peoples is a very stark and important way to show that there are other ways of interacting with the world around us, and to think about international law and to build our practice also around relationship and reciprocity with the communities in which we're working. It slows things down. It makes this work so much harder, but I think it's the only way to go forward in a way that is actually anti-colonial, and that is, it's a way in which we're building trust and working at that speed of trust to go forward, and we don't even necessarily know where it's going to end up. And I think that's the most unnerving thing for the law students and the lawyers is like, wait, we don't know what this case, the outcome is going to be. But I think that really the advocacy has to be that way in terms of what do our partners need and how can we walk with them in solidarity and do what they're asking us to do, because they know their situations better than anyone, and we have legal expertise that we can bring to the table, and that's what we're there to do. But we're also there to learn about how to advocate better, and that is to learn about different ways of interacting with the human rights framework, with the space, and trying to translate that worldview to rights that exist in either individual or collective rights. And I'm thinking about the Indigenous case now, but it could be any collective or community in which we're working.
Well, that makes me think about some critics' concern of a future World Court of Human Rights that it would be too Eurocentric or Western and like once again another colonial power. Uh, what are your thoughts on that?
Yeah, I mean, I think I think it's the devil's in the details, and right, like how is this going to be established, and who's at the table, and whose voices are, going into establishing this particular court and making sure that, all voices, the global majority is at the table when we're negotiating what a world court of human rights looks like, what its subject matter jurisdiction will, include, what, cases can come before it, who gets to come before the court in terms of standing. And, I think states are always worried about abrogation of their sovereignty. And I think that's ultimately the thing that we must contend with. Um, but I think the future, if we are really truly going to decolonize our space of human rights and international law, then we cannot continue with a Eurocentric approach because by nature that excludes half the globe or more, right? And so I think it's about who's at the table. We were just discussing and negotiating and thinking and advocating for a treaty on crimes against humanity. And I was at this I was on a panel, and I was on a panel with a representative from Mexico, representative South Africa, and then, civil society folks from various geographic regions of the world. And someone asked the question after the initial panel speaking, allotment happened, and during the Q&A, the person said, "Well, how are you going to involve the global South?" And I looked around and I said, "What do you mean? Are you looking at this table? This is the global South. The global South is asking for a treaty on prevention and punishment on crimes against humanity. And that's what we should be elevating. And I think, where this world court sits, who is on the court? How are judges selected? And is there a representation that is truly global and is even, affirmatively thinking about who has been excluded from, past international projects of quote unquote universality and making sure that they are represented at the table in the development phase as well as, when the court is operating and thinking about from the very top, the judges who are sitting on the court to the very bottom, the clerks, those who are, administrating in the court. We have to be conscious and think about how it really truly would represent the globe.
Thank you. Yeah, from the day-to-day work that I do, there's a perspective that the exclusive sovereign nation state system is really anti-indigenous. It's really, anti-earth and protection of the earth. It's kind of selfish. uh, but I don't feel like you have to comment that there are some individuals who have put some questions in the chat already, but I don't know. There was, I think Alex had a first question, and then there's a student, Abigail, who had another question. I don't know if you want to ask the questions yourself. Alex, yours was the first one I saw. Did you want to come off of mute and then ask that? If not, he said, do you think there's a human rights angle to sanctions, tariffs, blockades, and other forms of sabotaging the ability of large groups of people to make a living? If so, what enforcement options are there? So, I mean, maybe he's saying that there's some sort of a mass atrocity of sort of capitalist economic system that's impacting so many people's lives. That's how I would interpret that. But go ahead.
Yeah, yeah. So
Well, this is
oh,
this is not necessarily how I would interpret that. The way I interpret that is there is a long arm of a corpse of Thomas Malthus that drives our thinking and it drives our behavior. We believe that there is not enough earth for all of us, and therefore we tend to exclude people who don't look like us, who don't think like us, who don't, pray like us, and we use quite a variety of tools according to that ideology.
yeah.
And as a result of that, a lot of a lot of people who otherwise are perfectly capable of making a living can't. They don't get resources they need. They don't get education they need. They don't get finances they need. Why? Well, for no other reason than us not wanting them to, because we're afraid that if they get it, then we wouldn't. Okay. And we're not talking about, 5 indigenous people murdered. We're talking about millions of people suffering every day. Now, it's not a good idea to murder indigenous people or anyone else for that matter. But getting people under conditions where they have to fight for a sack of rice uh, instead of growing 20 sack of rice themselves. That sounds to me like a bigger problem because the rest of the problems in my mind appear to be derivative of this ideology. So the question is, if we admit that this ideology is the underlying cause of a lot of what's going on, what are the tools in our arsenal to fight it? Thank you.
Yeah. Yeah, I mean, I'm not sure if I'm the best person to answer your question completely, but what you're making me think about is the ways in which the human rights framework is limited. And there are certain areas in which intentionally, right? Like there is an intentional exclusion of certain perpetration or certain harm that is really outside the reach of human rights uh, law and redress. And the things I think about every day is anything that's related to economics and racialized or exploitative capitalism. We have very little tools in our human rights toolbox to address that, and that's by design. And so we have to think about how do we redesign or think about the architecture so that it does protect individuals from these types of harm. There have been, attempts through, let's say, business and human rights. There is, a draft treaty. It is not moving forward, and there's a reason for that. It's where power lies, right? Corporate power. It's extremely hard to penetrate and to think about structurally um, for redress, for accountability, and for prevention of harm. And so I agree with you that, our tools are rudimentary. We need um, to be creative and to be innovative and to think about, how do we actually create a legal framework, international legal framework that works for a majority of people. And right now it doesn't. It doesn't necessarily do that. I mean, there are emancipatory pockets and potential that were hard fought. Like I think about the reason that I'm so focused on genocide reparations and thinking about how do we reform our legal tools to include slave trade. It's because I think those are places where we do have the opportunity for speaking, truth to power in this way that you're talking about to really address some of the worst harms. But we do have to also think about labor rights as human rights. Right now, I mean, I don't know about you, but when I learned human rights law, nothing on the ILO. Like, not as an institution. I didn't learn about labor rights as human rights, except the fact that they're in the ICESCR somewhere in an article. But it's a whole area of, I think, human rights protection that we should be focusing much, much more closely on. Because it does touch on all of these drivers for atrocity that you are so eloquently talking about.
Thank you, Jocelyn. So there are four additional questions. I'd like to go to Rebecca first because I think she has another meeting to attend to. Then I want to go to Abigail, who's next, Dr. Elia, and then Alan. So Rebecca, if you want to start real quick.
Thanks so much, and I apologize if I'm cutting in line. I really appreciate the opportunity to speak with my friend Jocelyn. So Jocelyn, the project of the World Court for Human Rights seeks to solve one lacuna in international law. As we've been discussing, the architecture is perhaps insufficient to the need, right? And you mentioned in passing your work around crimes against humanity, as well as, of course, your work on the slave trade and slavery, which, along with ecocide, are now being contemplated as amendments to the Rome Statute of the ICC. And with regards to the Crimes Against Humanity Treaty, I was wondering if you could say a little bit more about the importance of that, where it is, and what gap it seeks to fill. Because as a World Court of Human Rights would take its operating jurisdiction from the corpus of international law, customary and treaty base, I think the CAH is incredibly relevant there. So thank you, David and
Yeah.
Jocelyn.
Yes, of course. Thank you, Rebecca. Thanks for the question. Well, I mean, I'm probably not the you know, first and foremost expert to talk about exactly what the lacuna is, but just in a general sense, we do have in our international legal architecture, we have the prohibition, we have a treaty for the prohibition of genocide. We have a treaty or a set of treaties for the prohibition of war crimes, which is, the genocide. I'm sorry, the Geneva Conventions, which is broader than that, but includes prohibitions for war crimes and grave violations of international humanitarian law. But we don't have a concomitant treaty that is addressing state responsibility for the perpetration of crimes against humanity. We do have individual ways to bring individuals to account for their individual perpetration of crimes against humanity, and that is largely through the Rome Statute now and the ICC, but you also have customary international law that can fill some of those gaps. But really, we don't have the state responsibility piece. And that is where this particular treaty would fill such a critical gap because enforcement, as we know, we're all talking about a world court, but enforcement is its best at domestic levels. And if we can get the international community to come together to sign and ratify a treaty, and we can get monitoring mechanisms to consistently monitor states' compliance with that treaty, and we can get maybe individual mechanisms for bringing claims, and the World Court maybe could be one of those fora when there are allegations of state responsibility for crimes against humanity, then we can focus on how to consistently hold states to account for either their perpetration of crimes against humanity, which does happen, or their failure to prevent crimes against humanity from happening within their borders. So it fills this absolutely critical gap. And we can see that, as we go forward in international lawmaking, we get better at it. We get progressively more inclusive about it, not only the process of lawmaking and who's at the table, and but also the actual crimes. And so this is also an opportunity for civil society to say, hey, this should also be a crime against humanity, and including things like gender apartheid and reproductive violence and other forms of violence that manifest when there's an attack on a civilian population. And so it's a really important piece, right, to sort of complete so in so many words the structure or the framework of international law. And where are we in that process? It looks like now we're going to go forward with a treaty, and we should have a treaty uh, negotiated and ready for signing and ratifying by 2029. But that means, and it sounds like a far away, date, but it really is not in terms of like advocacy and bringing civil society to the table and advocating around this particular treaty. It's kind of warp speed. So if anyone has any interest in thinking through or contributing to the process of advocacy around either particular crimes or the structure of how this treaty should work and operate. Right now, there is no monitoring mechanism, for example, in the Crime Against Humanity draft, which, civil society could say, hey, that's not good enough because that's right now how the Genocide Convention operates, and we need to go to the International Court of Justice, right? A state needs to bring that claim. But if we had a monitoring mechanism and then we had a protocol, the way that other human rights treaties operate and function, then individuals could bring claims or collectives potentially could bring claims for violations of the treaty. And so this is where civil society could play a real integral role. And I feel like we need to do that like yesterday in order for that to manifest in a treaty by 2029.
Okay, thank you, Jocelyn. Are you able to stay a few more minutes because we do have a few more questions? And
Sure.
before I get to Dr. Elliott and Alan, a question that really relates to what you were just saying is how can the public, whether it's in civil society or even as individuals, get involved? Abigail had asked, well, she says, thank you so much for your insight. What would you recommend a law student interested in engaging with this work, particularly in global health and disability justice and conflict? What could they do to get involved? And what could we do? And hopefully you can share with us, which I can put out later in our newsletter and other things, ways that we as the public can get involved in uh, these actions, these legal actions.
Yeah. So, I mean, I think that there are lots of ways in which you could be aligning yourself with some of the civil society organizations that are pushing forward these, particular the treaty specifically, but also these particular issues. If you're a law student, I mean, there's tons of ways to elevate these issues, to bring awareness to these issues. You could be running events. You might not know, but law school student driven events are, something that we really appreciate and want to elevate in law school. And so if you have a journal, if you're on a journal, you have power to, select particular articles or submissions that are on these particular topics, and that improves the awareness and gets, elevates these issues to a higher level of understanding and status. And then, I think that the Global Justice Center, Wash U is very involved in the Crimes Against Humanity draft treaty, reaching out to them and saying, how can we get involved? How can we, help to support this work? Avaz has a bunch of petitions. They're doing a lot of advocacy as well to get the treaty. Well, they were doing a lot of advocacy to get the treaty across this particular hurdle to get it into plenipotentiary. But now there's going to be so much more that will be substantive. And I think just, starting to ask who are the leaders and how do I, get in touch with them and how do I just put myself out there that I'm ready and willing to do it. And I think one thing I would say to law students, because I do see this happening as a trend, you do need to go deep. You need to read, you need to research, you need to look into these issues. Pick it as a topic, as one of your, papers that you have to write for any class, right? Go deeply into the issue. It's hard right now. There's so much information coming at students in bite-sized pieces, but that makes us jack of all trades, master of none. So become an expert on something that you're passionate about, because that could be, where you really add value to whatever the, advocacy is going forward. Write something, get it published. You might be a student now, but the minute you graduate, you can publish it as an attorney, a practicing attorney in the field. And so, yeah, I just say like go for it in whatever way you think you want to insert yourself into the movement. There's no one movement for human rights. There are lots of movements for human rights. And so just figuring out where you fit and how your skills are best matched in the particular movements that you want to be a part of. The disability justice movement is amazing. There are so many amazing advocates out there at intersections. Even I work a lot with this one organization that is at the intersection of reproductive justice and disability rights justice. And they're getting involved more and more with the crimes against humanity issue. So yeah, like we can talk later. You can send me, an email and we can think more concretely about how you particularly can get involved. But there's so much work to be done and there's so much need in the space. So I would encourage you to definitely get involved.
Thank you so much. I really appreciate that.
Thank you for that advice. Now, Dr. Elia has a question.
Yeah, thank you. Can you hear me well?
Yes.
Thank you very much for this meeting. I'm really enjoying to hear you. And actually, I think that I have so many questions that I need a session to to introduce all of them. So, greetings from the other side of the Atlantic Ocean. I'm from Spain. So I really appreciate to join you for the first time. So before the question, I just want to fully subscribe of what you say about the fact that human rights is a daily engagement in practice. It's not a work, actually. It's our passion and our mission, you know. So I totally agree with you about that. But I have a few questions and maybe perplexities, why not, about the World Court. The first one is I'm curious about what is the distinction for you, if any, about atrocity crimes from one side and crimes against humanity? Because you mentioned you did reference to both. This is the first one. The second one is in relation to the structure of the court. So are you sure that we really need a new one court? And then maybe we can have other options. For example, my interest is over the possibility to create special chambers inside the International Court of Justice, like, for example, Professor Cansado Trindade, former judge of the court, mentioned about, just to have any kind of opportunity to have in place any measure of accountability for states. And the other point I'm interested is about the involvement of, I don't really like the expression actually global south, because to me, from my point of view, is an extension of colonialism to mark a section of the globe.
Yes.
So we have, but it's my personal opinion, so I don't
It's why I also use global majority. Yeah,
exactly. Because I used to say to my students that the world is full of south. It depends from where you look.
It's a ball.
Exactly.
Kind of flying through space, right?
So maybe I'm too much optimistic about international legal order. We need to be optimistic since the obscurity of the reality. But I saw, at least in the last 20 years, and it is still a process, of course, a more an increasing engagement of new, let me use that term improperly, countries contributing to the development of substantive international human rights law, like, for example, you quote labor rights. And I just had a memory about my work in Geneva over domestic migrant workers. So the contribution and impact that that part of the globe had into the definition of those rights were fundamental. So I think that it is still a process. I'm not sure that there is still a Eurocentric vision about human rights, because in the international fora, like Human Rights Council, for example, there is an increasing impact of such countries, many countries of that. You mentioned Mexico, for example, and when I was there, I saw the level of engagement, not only at academic level they had over that. So I'm curious about these 3 points, but I have really a lot of questions. For example, about your institute, you work, you mentioned collective rights. So I imagine you only follow minority rights cases, or are you oriented also over individual cases of a specific person in the group, for example? So,
Yeah.
So
Okay.
maybe I can send you an email with the rest.
So, to answer the last question, we do strategic litigation where it involves one particular litigant. Often we are not of counsel. Often we are attached to those cases because they are so long. They are usually 10 to 15 years long when they traverse, a domestic system into an international or regional body, right? So we normally come in and out of those litigations with those strategic litigations with partnerships. And the organizations that are taking them on, we come in when there's something we can add value to. For example, we will engage in an expert, will help an expert prepare for testimony, or will prepare their expert report so that because a lot of these folks are, volunteers and are doing this work pro bono, and so they need that assistance. And so I feel that our clinic can add a lot to accessing resources and research and providing all of that technical assistance to get someone to be able to contribute to those international cases, for example, or we'll do an amicus brief. We've done that in several different cases at domestic constitutional court levels, or we do them, in international fora. Um, but yeah, so to answer the first question, um, when I say atrocity crimes, I'm really thinking about international crimes, I guess, technically. And I think more broadly than the Rome Statute, but you can think about, I think atrocity crimes is the label that is put on uh, genocide, crimes against humanity, war crimes, and the crime of aggression. And then there are proposals to add other crimes to the Rome Statute, like ecocide. I would also put international crimes into that bucket, and that could also mean slavery and slave trade. Even though under the Rome Statute, they are only listed as crimes against humanity and or war crimes, they are also, because of the nature of the treaties and the way in which international law was made, they are also in and of themselves international crimes, the way that torture is, for example. So I consider torture also could be, right, a Rome Statute, quote unquote, international crime, one act of torture, but it just was not included that way. It was only included as a crime against humanity and or as a war crime. So that's what I mean when I say atrocity crimes. And I'm so glad that you asked because we also, we work with acronyms and things and I traverse lots of different areas of work too in the public health space, in the atrocity prevention space, in the legal space. International law uses so Latin terms and silly acronyms. So please always call us out on that when you're unclear what exactly we mean. And then I'm trying to think of the second question. I didn't write it down. I was
She said
thinking I got,
special chambers in the ICJ, perhaps that instead of maybe
oh
having a
yeah.
separate court.
Yeah, so my reaction to that, which I haven't thought really incredibly deeply about the World Court, to be honest with you. I mean, this is an exciting development, and I'm excited to learn more about it. But my initial reaction to that is that that is still, the ICJ is still extremely state-centric as a model, right? Like a state needs to bring a claim. So you need to convince a state that it's in the state's interest to bring a claim. And that could really run counter to a lot of our advocacy and strategic litigation in human rights, especially when it comes to groups that are not necessarily even like acknowledged by the state. And often indigenous groups are in that category. So the World Court seems to me to be a place where individuals and collectives could also bring claims in and of themselves. And that's not to say that there aren't other venues for that. There are. But if we have a world court that is considering comprehensively the corpus of international human rights law, we would have, maybe filling some of those potential gaps that exist today, where we sort of have to retrofit some of our claims into, for example, if we're thinking about environmental harms or whatever, we have to think about how are those going to fit into the human rights that we have that are already existing in international human rights law. And then we have to think about what state has ratified what treaty, can we bring it to this particular venue, and I mean, sometimes we can forum shop because sometimes states sign a lot of treaties and then we have a lot of options. But sometimes states do not, or they've gone in a different direction, right? They started out by signing and ratifying treaties, and then there's been this regression and no longer engage in that, of which the United States is a guilty state of doing that very thing. And so we don't necessarily have all of the tools that we would want in our toolbox to bring these claims. I think about all the time, we have the US has signed and ratified the Convention on the Elimination of Racial Discrimination. But query as to whether indigenous population, they have been considered to be racial group, but query as to whether that's actually accurate from the indigenous perspective, right? Because honestly, they were dealt with as nations at some point. And then colonialism has eroded that initial, engagement of nation to nation. So, yeah, it's just sometimes it's inadequate to deal with some of the human rights questions, concerns, and real harm that folks are experiencing. So that's my initial reaction to that. I do think if we had chambers within the ICJ, that's great too. And there's been a lot of activity because, human rights lawyers are so creative and awesome that there's been all this activity at the ICJ that we haven't really seen yet, right? And I think we're capitalizing, I hate to use that word, capitalizing. We're taking advantage of a moment in time where we have regionalization, which isn't not necessarily great on all aspects of the world, but we have, sort of this turn away from, internationalism, and we're in this regional time where there is this window of opportunity where states might be realigning. And then there is this opportunity of getting a state to bring another state to the ICJ for human rights violations. But we have not seen that in up until now, right? And so who knows if that will ebb and flow, if that will, if the pendulum is swinging and we haven't yet seen where the opportunities lie, or whether it's going to swing back and we'll see a regression on those particular claims brought before the ICJ. But I wouldn't lay all my eggs in the ICJ basket. It's a great place where there is some legal action today on very important issues in the atrocity crime space, and specifically prevention and mitigation of atrocity harms. But I don't think it's the panacea. There was another question, and I'm not answering it.
Well, Dr. Elliott, was it something really quick? Because we still have one more question from Alan Ware, and then we probably should end our meeting because we're already almost 20 minutes over.
I'm sorry.
No, I'm so glad that you could stay with us. I'm just worried about, everybody's
Oh no, maybe
time frame.
maybe I can send an email. If
Sure.
we can share the email, I will be happy to make more comments and stay
Absolutely.
in touch. Thank you.
Yeah, I encourage everybody to send an email directly to Jocelyn or through me, and I will pass those along to her for answer for all of us. But yeah, thank you. So I guess for our last question, we'll go to Alan.
Yeah, thanks very much. Great to see you again, Jocelyn. We were just in The
Yeah, good
Hague
to see you.
together
Good to
for
see you
the
too.
Assembly of States Parties to the International Criminal Court, which was happening at the same time as the International Court of Justice hearings on climate change. And it was really a great opportunity in The Hague, over those week and a half or 2 weeks to see some of the interplay between the ICC and the ICJ. A question I'm going to ask is about interplay between the ICC and this proposed International Court for Human Rights, or World Court of Human Rights. I think, what we have with the ICC is we have a court, but its jurisdiction is only over certain crimes. One of the questions is the crime of slavery. On December the 2nd, the ICC put out a new policy guidelines on how they can deal with the issue of slavery, but I understand that's still very limited. So I'm just interested in your thoughts of how far can one go, on accountability for slavery under the ICC, and how much we might need. One of the other reasons for a International Court for Human Rights, to pick up the things that we wouldn't be able to get through the ICC. So that was the first question. And the second question is, we are now seeing political threats, and economic threats to the ICC, from the United States government. And I know Rebecca's left, but she chairs the Washington Working Group of the ICC, and most of their work's going to be like, how do we try and minimize, what the US's government do? Because, what are the threats? Arrest warrants against judges and, freezing assets and things. It's horrific. One reason for this, of course, is that these tribunals are actually having an impact. They're actually challenging the powerful, and the powerful corrupt, and the powerful and corrupt don't like it, and they'll try and fight back. So thinking of when we move to setting up a World Court for Human Rights, there will be similar dynamics. It'll be challenging some of the corrupt powerful, and how do you protect the court, from, what the powerful corrupt autocrats, might be doing. Thanks.
Yeah. Wow. Those are two really great questions. So the first question about the interplay between the ICC and the proposed court, and thinking about that through the limitations on being able to seek justice and accountability for slavery crimes specifically. Yeah, I mean, specifically, the ICC is really only going after those who are the architects, right, of atrocity crimes, and a limited amount of atrocity crimes. It's not even reflective of customary international law, which is a broader set of crimes that we could, bring individuals to account. But the ICC's jurisdiction is limited in that regard, where whatever is in the statute is in the statute, and we can't use substantively any crimes outside of that statute. So because the slave trade is not enumerated, even as a crime against humanity or as a war crime, that crime cannot be adjudicated at the International Criminal Court at all. And slavery, while it exists as enslavement, enslavement is defined as slavery under crimes against humanity. It's missing from the war crimes provisions. The only crime is sexual slavery. And so only the more specific form of enslavement can be adjudicated under the ICC as war crimes. So you can see there's, architecturally, we are structurally problemed to start. We can't even investigate, prosecute, and punish certain crimes. The states could choose to reform the Rome Statute. They could, add amendments to the Rome Statute, and they should, right? But that also makes implementation more piecemeal, because with every amendment, you have to have states have to affirmatively take those amendments on. And so then you have this more of like a, web of accountability that has potentially holes in it if states decide they want to affirmatively not accede to a particular amendment to the Rome Statute. And because we are in a system where states affirmatively take on any obligations under international law, and if they do not, then they do not have those obligations unless it becomes customary, as everyone probably knows on this call. But that means we have a system that is imperfect in its ability to implement. And, the ICC really is only looking at individual perpetration, and the World Court is looking at other forms of responsibility, which I think does round out the legal architecture in really important ways and allows for state responsibility. It allows for different ways in which we can focus on victims, survivors, right? In criminal cases, victims and survivors are complaining witnesses. And the ICC has allowed for victim participation in a way that is sort of unprecedented and increasingly so, right? But that doesn't take it isn't the same as a petition being brought by the individual who is harmed, and that individual being centered and the subject, right, of international law and redress for that particular harm. So I still think that there is a need for that world court, and I don't necessarily. I don't ascribe to, the idea that, oh, we already have enough. Well, clearly there are still human rights violations and multiple harm perpetration happening across the globe, where we either don't have a venue to bring these claims, or if we have a venue, the court is backlogged and not able to hear or address those claims. So I don't necessarily think that that I guess those arguments don't persuade me that there's no need for a court, even if piecemeal you could take these various claims to lots of different venues and lots of different places, including domestic law. There are always challenges and impediments. And then your question about the politics. I mean, I think that happens at the level of domestic law as well. It's just that I guess I always think about international law as being more like the Wild West, like you kind of see it more when you get up to the international level because, the politics are just, the states as being the center of international lawmaking, it makes the politics sort of more, visible in a raw kind of way. But I don't necessarily think that that's, um, unique to international law. And I think we just need to think in advance that this is a reality of the international legal system, that we are going to have attacks when it's not selectively implemented. When rule of law is actually working as it should, that's when power starts to reel its ugly head or whatever you say. Like that's when you start to see the cracks, right, in the architecture, so to speak. And so I think that if we can just address them, knowing what we know now about the challenges with the ICC, we should be thinking about how do we learn from this experience of, states sanctioning an international body like the ICC? How do we develop, some antidotes or like inoculations in a World Court of Human Rights for that to be something that is not a common practice in a future World Court scenario? That, how do we take what we're learning now and build the 2.0 version of, international legal architecture that is more resilient to the ebbs and flows of power and the ways in which hegemonic power, and colonial type of power comes to bear or becomes visible in that international architecture. That's I don't know if that's a really probably not satisfying answer to you, Alan, but
Well, yes, because you expanded the question to look at domestic politics and law as well as international. And I
yeah.
think, many of us have experience at defending national judicial systems from the politics, sometimes successfully, sometimes not so successfully. And so this is a really good answer because it actually sees that the judicial institutions do not exist in a vacuum. There has to be
Yeah,
political support for them, and part of our work is to build that political support.
exactly. Right? Like when courts are legitimate and when they're serving the population that they're meant to serve, then the legitimacy is felt, and there is a lot less ability for states, especially in the international sphere, to attack those institutions. But you see, right now, in the United States, the Supreme Court of the United States, the legal architecture is being challenged in ways that, I think isn't unprecedented necessarily, but is politics through other, we're seeing those politics happening and the real ramifications of political decisions. And I think that keeps us understanding that democracy, rule of law, all of these fundamental values and ideals that we are holding as, ideals that we want to be ensuring are happening in our particular places close to home and globally. They're things we have to fight for constantly. They're not just we shouldn't be taking them for granted.
Yeah, it looks like Dr. Elliott has a comment I would like to say just to bring me back to my constitutional law class. Hold on, Dr. Elliott, let me just make this point, that we want to make sure that the World Court of Human Rights is a counter, is not a, or is a counter majoritarian or a majoritarian opportunity and not a counter majoritarian or counter democracy negative. But anyway, go ahead, Dr. Elliott.
No, just thank you very much for giving the floor again. It's just an expression of solidarity with you, because you mentioned the Supreme Court of United States. So think that a little country like a mosquito, Italy, at this moment when we are talking, is lacking 4 members. So the Constitutional Court in Italy is working without 4 members, because there is no political agreement inside the parliament to nominate the new 4 ones. So you see that global challenges and global solutions we need. Thank you.
Well, thanks, Dr. Elliott. And thank you so much, Jocelyn, for your time with us today. I'd like to leave the floor with you here, making any final comments, suggestions, concerns that you'd like to state that relates to your work with Indigenous people, with public health, with mass atrocities, and maybe how that relates to a future World Court of Human Rights, and any final comments that you'd like to make.
Well, I just want to say thank you for this opportunity to engage with you all and to learn as well from you and with you, and to just say that, keep dreaming, because these are the things that lead to the next, right? Like the next iteration of what human rights law can really bring to the world and to individuals on the ground, and to people who are fighting every day for their right to exist, to be included, and to live lives with dignity. And I mean, that's what this whole project is really all about. And it's imperfect. And so we need new solutions. We need new ideas. And even if you think it's something that's a pipe dream, I just always go back to Ben, the namesake of the clinic that I run. Ben had an idea, and it was a long time and a lot of setbacks and a lot of heartache, but in the end, it came to fruition. And even Ben would have said, "Oh, this is just the first iteration. We're going to see something better." And in the course of 100 years of his lifetime, he could reflect on how the world had changed, and he could have that perspective of someone who had lived a full century of life. But he still was like Sisyphus, pushing that rock up the hill and never giving up. And that was his mantra: never give up, never give up. And then he would point to you and you would have to say, never give up. And so don't give up on these ideas, and know that every, year or minute of advocacy that you're doing is saving someone that year or minute of advocacy in the long run to making it a reality.
Thank you so much, Jocelyn, for those words of support. And about a year before Ben died, I was able to get an email from him where he said, "Of course, David, we need a World Court of Human Rights." So even Ben was, in support of this. And yes, we're never going to give up, no matter what people say. Oh, that's not possible. Yesterday's utopia is today's reality. So we need to make it happen, and it has to come from us, the people, right? Yeah. Jocelyn, thank you so much for your time today, and everyone involved in the Zoom conversation today. I really appreciate all of your questions. We will be meeting again. I'm not sure if that'll be January or by February, but you'll all be in the loop. And there are some people who've given me their contact who I will information. I will reach out to you, Jocelyn, with their information so you can reach out to them. So thanks again so much for this time today. I sincerely appreciate it.
Thank you.
Thanks,
Have a
everybody.
great day and
Thanks,
happy
Jocelyn.
holidays. Happy New Year.
Thank you. You too.
Happy
Bye-bye.
New Year. Thank you.
Thanks, everybody.
Happy
Bye-bye.
holidays and thank you.